right, let's do it.
Perfect. All right, well, hi and welcome. I'm Rob Hamrick. I'm the Director of Development and Client Relations at Stuart Green Law. I'm going to be one of your hosts for today's webinar. Stuart Green, our founding attorney, he's with us as well. I'll let him introduce himself here just in a moment. Today's webinar, it's an introduction to estate planning for high net worth clients, business owners, and their families. So to paint a picture, the sad reality is that nearly 90% of us do not have an up-to-date comprehensive estate plan in place to protect ourselves, our family, our wealth, and our businesses. So we're excited to introduce these fundamentals of estate planning. Of course, it's a webinar, so we have some administrative items. So let me quickly go through those. First, this is not legal advice. It should not be construed as such. So if you have questions about your estate or today's presentation, schedule a consultation with Stuart. Second, we're going to try to keep this as non-technical as possible, as a lot of this is new for many of us. We want to help you understand why it's important rather than all of the mechanics. We're going to keep this around 30 to 45 minutes, probably 30 to 40 minutes, unless Stuart, is just rambling on. I'll try and rein him in, pull him back here. We shouldn't go over 45 minutes though. Regarding Zoom, we've turned off your mics and your cameras just to minimize distractions and background noise. And then for the most streamlined viewing experience, there's the little view button in the upper right-hand corner of your Zoom window. If you click that view button and then click hide non-video participants, that will give you that most streamlined view. All right, so I'll go ahead and kick it over to Stuart at this moment.
Great, thanks, Rob. So like Rob said, I'm Stuart Green, the founding attorney of Stuart Green Law. We are an estate planning practice headquartered in Houston, Texas. We also have an office in Louisville, Kentucky. We're a bit unique in that we focus on solving several problems that other attorneys don't really focus on. So first of all is tax, not just estate tax, which a lot of attorneys do, but also income tax planning, which we'll talk about in more detail. Second is asset protection. So a lot of times people are thinking about asset protection in the terms of Medicaid planning. That's not relevant to our client base. So we'll explain what that looks like for high net worth clients and business owners. And then lastly, multi-jurisdictional estate planning issues. And we'll talk about what that means in more detail as well. But these are three things that are pretty unique to our practice. A little bit more about me. I've spent my entire career working with estate planning law firms or in public accounting. The law firms include national boutique, high net worth estates and trust practices. And then in public accounting, I was with Ernst & Young, one of the big four international public accounting firms focused on multi-jurisdictional tax issues. So I'm going ahead and sharing our contact information here, and you can see that. You'll probably have questions after today's webinar, so feel free to reach out to me or Rob. Pretty simple. It's Stuart at stuartgreenlaw.com, Rob at stuartgreenlaw.com. Give us a phone call. Go to our website to learn more about what it is that we do and how we help clients. We also have a lot of content on YouTube, so you can go there and check out other videos as well. Two things that we're excited about today. I'll explain the first one, then Rob can explain the second one. But anyone who is registered for the webinar can sign up to have a free consultation with us to discuss anything that you may have heard in the webinar or anything regarding your own estate plan that you might want to do. Easiest way to do that is probably to go to the website, fill out our online questionnaire, which just asks for a snapshot of some personal information, gives us an idea of where the conversation should go, and then we'll coordinate with you best time to have that. So take advantage of that. There's a lot of value there, and then I'll let Rob talk about the other thing.
Yeah, absolutely. So we focus on our legal services for high net worth individuals and business owners, but really we're trying to do everything we can just to help them grow and maximize their business. So we've partnered with Cultivate Advisors, and they're one of the largest business growth and value advisory firms in the nation. So Cultivate, they're going to offer any business owner that we, refer them to a free 2-hour valuation and growth assessment. So they're fantastic because they're going to be looking at sales, profit, talent, leadership, marketing, performance improvement, and they're going to provide strategies and benchmarks in all these areas. So if you don't have questions even about like what Stuart and I are talking about with the estate planning, but you want us to introduce you to Cultivate advisors will be happy to go ahead and do that. So you can take advantage of that 2 free hour business valuation and that growth assessment. So just reach out to us and we'd be happy to put you in contact with them. So jumping into estate planning, Stuart, I always hear you put a particular emphasis on comprehensive estate planning. I think it'd be helpful if you explain to everyone what you consider the 5 pillars of comprehensive estate planning.
Yeah, so 5 pillars, you can probably break it out to more or less, but this is just what we focus on. So first, and we'll talk about every single one of these in more detail, so I won't spend a lot of time explaining it right now. But first step, estate planning, those are the documents that every person needs, regardless of age. Next is asset protection. I kind of talked about that a second ago. So we're focused on protecting assets and wealth from lawsuits, divorcing spousal claims, bankruptcy, other type of legal risk, succession and legacy planning. So business owners and wealthy clients need a documented plan for the continued success of the family business or wealth once he or she becomes incapacitated, retires, or dies. One of those is inevitable, so you got to have a documented plan. Income and estate tax planning, like I said, we'll dive into that a little bit. And then charitable giving. So most wealthy clients, they have causes that are very close to their hearts. They want to give back. They want to contribute. We talk about doing that during your lifetime, as well as maybe what a charitable legacy might look at. So there's tax planning aspects to that, as well as a few other things.
Yeah, so let's talk about why estate planning is so important. I always tell people that effective estate planning is your documented, your legally binding plan to protect you, your family from a variety of legal, financial obstacles, in the worst of situations. And probably most importantly, it's going to preserve family unity. Recently, I was talking with a couple, and unfortunately, there's a lot of family infighting because estate planning wasn't done correctly. So that key piece of family harmony is extremely important. So it doesn't matter if, the legal and financial obstacles are foreseeable. An effective estate plan is going to make sure that you cover all your bases regardless of what happens. So to begin to understand why it's so important, I think it would be helpful to understand what happens when you pass away from a legal perspective. Stuart, can you provide some guidance on that?
Yes, I can. So, regardless if you have a last will and testament or if you're married, assets owned in your individual name have to go through the legal process known as probate. Most people have heard of probate. Maybe they've gone through probate when they've lost a loved one. But so to give you an idea, each state has its own version of probate. But in general, someone will have to be appointed and serve as your legal representative or your executor. People are familiar with that term. Serve as the executor of your estate in legal proceedings, prepare numerous court documents, pay any of your remaining debts, distribute your assets, and change legal ownership of your assets. And this is all done while a judge at the local district court oversees this entire process. Yeah.
I've yet to meet a person that likes going through probate, except for probate attorneys, and that's where they make their money. They get paid when they go through probate. So or helping people go through probate. Why do people dislike probate so much?
So first, the obvious is someone you love just died, right? And now you're having to deal with attorneys, judges, courts, financial institutions, lots of paperwork. It's just burdensome at a particular vulnerable, sensitive time in your life. But bottom line, it can be very expensive. It takes a long time, and assets can get frozen and you not have access to them. So just to kind of give you an idea, on average, probate cases cost anywhere between 3% to 8% of an estate's value. So additionally, on average, it takes approximately 1 to 2 years to close a probate case. A lot of times states will say that there has to be, it could be a 6-month window where creditors can make a claim, even if there aren't any creditors, and that a probate has to be kept open 6 months for creditors to be able to make a claim. So at very least, you're looking at probably 8-9 months to get things really closed out. But again, it can take a lot longer. And you see this 7 on the slide. I keep meeting people who just keep, they keep pushing the bar up and up and up. So until a few weeks ago, the longest I'd seen anyone in probate was 5 years. I was having a conversation with a lady, and she told me that they were dealing with year 7. They were into year 7 of her husband's parent, one of her, I think her husband's father's estate, and that there was, to Rob's point, a lot of fighting within the family. There was challenges being made to the estate plan. So point is, relationships within a family can sour pretty quickly and break a family when there's bad estate planning or just not proper care for the actual estate plan when it is carried out.
Yeah, but the good news is you can avoid all that, right? You can avoid all that probate. So, with that said, let's talk about the documents that every person needs to, everyone needs to make sure that they have their legal, financial, tax, business, and family affairs in order to avoid probate and to avoid, these emergency situations and unnecessary obstacles. So these are the first step estate planning documents you referred to earlier. Can you just walk us through these documents?
Yeah, absolutely. So, and again, this is focused at high net worth clients. So maybe you see revocable living trust on there. That may not be for everybody, but with the certain clients that we're dealing with, 100%, it's part of the basic document. So we will start with the last will and testament. So if you die with an executed will in place, you'll have laid out all your intentions and your wishes regarding the distribution of your assets, who will raise any minor children, if that's applicable to you, and appoint someone to be your legal representative or your executor to carry out your remaining legal affairs. So 2 things to keep in mind. First, if you die without a will, each state has its own laws that will determine how your assets will be distributed. And then second, a last will and testament doesn't keep you out of probate. It just makes sure that throughout the probate process, your intentions are honored.
So the last will and testament, it's not keeping you out of probate. Why is it so important?
Okay, great question. So in addition to what I just said, it's going to appoint a legal representative, typically known as the executor, to handle those affairs, right? There can be affairs that happen outside of the probate process. So let's say you were in a car wreck and you died. Maybe somebody ran a red light and hit you and you passed away because of that accident. Your estate, your family might want to bring a wrongful death suit on your behalf. Someone has to be able to do that. Someone that has a legal claim or legal standing has to be the one to do that. That would be the executor. Or maybe someone's going to sue your estate. Maybe it's a creditor, or maybe it was your loved one who ran the red light, caused an accident, and passed away. Maybe someone's going to sue them, right? So you need that legal representative to be able to take care of that. And then lastly, there's likely a final tax return that's going to have to be filed on your behalf. So that's something the executor or the legal representative would take care of as well.
All right. So do you have any unfortunate examples of maybe a business owner that hadn't set up a last will, and testament?
Yeah, I think, quick Google searching, you can find a few different examples out there. I think kind of the one that pops up in most recent years is the CEO of Zappos, the online shoe and clothing retailer. I forget all the, details about how he passed away. I think it was like in maybe a house fire that he started. But he was young. I think he was in his mid-40s. He died without a will. And he was worth approximately $500 million. And so I think this was 2 or 3 years ago. It's still going through the court system. There's been a lot of challenges. Friends, family are coming out of the woodwork saying, he promised me that he was going to give me a few $1 million if I did this for him or did that for him. And so it's just a huge, huge mess. And then even on a more personal level, during COVID, I had a friend's father who came to me. We had an initial meeting, sat down, talked about his and his wife's estate plan. Long story short, he ends up dying 2 weeks later, unexpectedly, before we could do anything to update his plan. So when we sat down and we started looking at his previous will, what we realized is that when he did it 25 years ago, it was not properly executed. And so he ended up dying without a valid last will and testament in place. So here we are over 10 years later, over 2 years later, approximately worth about $10 million. Most of that was in a closely held business interest. And so now we're going through the court system, fighting with partners, fighting with the actual business itself, other family members, trying to make sure that all of this gets sorted out. The spouse receives all of the business interests. Otherwise, the spouse doesn't have really have any assets, because everything was in the spouse who passed away in his name. So a lot of issues just come up, and it just takes a long time to work through the process.
Yeah, and probate is a public process, right? So it can result in assets being frozen for months or even years. If you have real estate or business interest in other states, you might get pulled into probate in other states. So it sounds like it's a lot. So how can a client and his or her family avoid having to deal with probate?
Yeah, and so this is where the last will, or where the revocable living trust is really important to wealthy families. At the very minimum, they really do need it. So in general, you can use beneficiary designations to transfer some of your assets upon your death. Think about like investment accounts, maybe some bank accounts. But other assets have to be titled in the name of the revocable living trust if you want to avoid having to go through probate. So the way that it works is assets titled in the name of the revocable living trust rather than in your individual name avoid probate simply because they aren't in your individual name. So it's just a matter of changing the legal ownership. But the great thing about this is that with the revocable living trust, you yourself are named the trustee, you're named the beneficiary. So that just means that you manage the assets and you use the assets, you benefit from them in the same way as if everything were in your individual name.
All right. So speaking more to business owners avoiding probate and the use of the revocable living trust, how does that all play out?
Yeah. So if you intend on passing a business interest through the probate process via your will, you run the risk of bringing the business operations to a complete stop until the business interest can legally be transferred to the new owner, whether that's someone in your family or someone else. So again, if you go the route of a last will and testament, go through probate, it could take months at the very least. And if there are challenges or other issues that might pop up, maybe with a shareholder agreement or an operating agreement, then you could be looking at years before this gets resolved. And this, obviously is not a recipe for continued success for any business. So using the revocable living trust to transfer ownership outside of probate circumvents any of these issues.
Yeah. So only 20% of organizations have a formal documented succession plan in place for a transition, which is crazy, 20%. I feel like there could be other implications for business owners, though. So let's say something happens well before that formal succession plan actually is worked through. And so what happens if the business owner has a wreck, is involved in a car accident, has a stroke, heart attack, has Alzheimer's, becomes incapacitated? Who
Yeah.
runs the business at that point?
Yeah. So it just depends. We don't always know off the top of our head. It has to be worked out. So if you do become incapacitated, you need someone who can step in and make decisions regarding your financial and legal affairs, pay your bills, apply for public benefits if that's a thing, and to your point, run your business, right? So in a power of attorney, the document power of attorney, you name an individual or individuals who can do just that. Otherwise, you're potentially looking at a jury trial, psychiatric evaluations, other medical assessments to have someone appointed as your legal guardian or conservator. And so again, you're leaving it to the hands of the state and the judge, potentially jury, to figure out what's best for your business and who's going to run it. So I know we're going to talk about a formal succession plan here in a little bit, but these simple things are easy ways to make sure that you don't run into huge legal and financial obstacles.
Yeah, so the last three documents, they all have to do with healthcare, like some concerning healthcare. The term is advanced directive, but in reality, it's three documents. Can you just walk us through those documents and how they work?
Yeah, so an advanced directive includes these three items, and I like to break them out into three separate documents for different reasons. Well, I won't go into here, but the healthcare surrogate designation or medical power of attorney, healthcare power of attorney, It works similarly to just the regular power of attorney. So it gives an individual or individuals authority to make healthcare decisions on your behalf if you do become incapacitated. The HIPAA authorization works in conjunction with that. So that gives your medical agent, that medical power of attorney or healthcare surrogate, access to your healthcare information to be able to make informed decisions when something happens to you. And then lastly, living will. So that specifies your wishes regarding end of life issues. Think about medical treatment, ventilators, food, water, medication, pain relievement, that type of thing. So that makes your wishes known to your medical agent as well as your doctors and anyone else. So these are by far the most important documents that everyone has to have to begin having an effective estate plan.
Yeah, absolutely. With my wife being an ER nurse, those and being in the ER, those are some very important documents there when it comes to healthcare. Absolutely.
Yeah.
So we spent a lot of time on the basic first steps, which is that first pillar that we talked about. So let's transition into the other pillars that you mentioned earlier, which is where we're going to start looking at more advanced estate planning techniques. I hear you say that the most overlooked aspect of estate planning is asset protection. So first, why is asset protection important to business owners and high net worth individuals and families?
Yeah. So this is where estate planning starts to really take on its nuances and start to add a lot of value to high net worth families and individuals and business owners. So business owners and high net worth clients are under a level of legal scrutiny that others aren't, right? So approximately, and this is pretty crazy, 94% of the world's lawsuits happen in the US. Whether it's a negligence or malpractice suit, bankruptcy, divorcing spousal claim, or some other type of legal risk. If you don't protect yourself, then a creditor can obtain your business or personal assets from you. So there's different strategies, there's different ways to go about this, but asset protection trusts really are the most effective way to do it.
So you said it's the most effective way, those asset protection trusts. Are there ways, are there other asset protection strategies out there that are falling short, that aren't working?
Yeah, absolutely. There's a lot of strategies out there that aren't strategies at all. So first one, retitling assets in the name of a spouse or a child. There is maybe, I understand the theory behind it, but the problem is with this approach, you could end up getting divorced or maybe, an unexpected death. So in that event, you lose access to those assets. Or if your spouse or child ends up with a creditor claim against themselves, then this could potentially cause you to lose the asset to that creditor as well. Second strategy that's not really a strategy is expecting your umbrella policy, your business insurance or your malpractice insurance to cover everything. Insurance, and rightfully so, insurance policies have limits that are clearly defined. So, every injury isn't necessarily going to be covered. And there's, policy limits on how much is covered, right? So sometimes creditors are awarded much more than whatever insurance might cover. And then lastly, LLCs, limited liability companies, they're really strong options. We love them and we certainly use them as part of our strategies, but they too have limitations. We won't go into that here, but just to kind of give you an idea, LLCs are best used in conjunction with asset protection trust.
All right. So, the examples that you just said, or those items you said, the insurance, and putting, an asset in the name of someone else, they're falling short. So that's why we need asset protection trusts. But how do asset protection trusts provide the best asset protection?
So, yeah, great question. First, it removes assets from your personal name. So it's going back to that idea, of getting assets out of your personal name, but you're not giving them to your child, you're not giving them to a spouse, you're giving them to a trust. So the trust owns the assets, not you, not anyone else. And that's really important because the second thing here is that you will benefit from the trust assets either directly or indirectly. Even though you don't own the assets, someone else doesn't either. The trust does. And we can orchestrate it where you will still benefit from the assets in the same way as if they were in your personal name. And then third, effective asset protection trust planning is is not going to be impacted by death or divorce. So the trust will always own the assets, and we will always have a way to access the assets regardless of what happens.
So are there specific types of trusts that provide the asset protection?
Yeah, there are two situations where trusts provide asset protection. First one is what's called an inheritors trust. It's known as a third-party settled trust, meaning someone else sets it up for the benefit of another person. So a typical example of this would be when mom and dad are passing an inheritance to a child, and they set up a trust for the child rather than giving it outright to the child. So inheritance should always be transferred to an irrevocable trust rather than outright to the child. So, and the reason for this is to the extent that the inheritance is passed to someone inside an irrevocable trust, those assets remain in the trust. Those assets are protected from any type of claim from a divorcing spouse, any type of lawsuit, negligent suit, malpractice, bankruptcy, whatever it may be. And I've yet to meet a person that didn't want to protect the family wealth from creditors and predators, as we say. And then next is first party settled trust. So these are domestic asset protection trust and foreign asset protection trust. So kind of to give you a little historical context, a little background here. So these are known as self-settled trusts, meaning that you can set it up for the benefit of yourself. And historically, you yourself have not been able to set up a trust for your own benefit and the assets be protected from creditor claims. Back in the 80s, all of this changed. Several offshore jurisdictions passed laws changing the trust industry and allowing a person to set up an irrevocable trust for their own benefit while protecting the assets inside the trust from creditors. Cook Islands and Nevis, they're both small island countries, became really well known for their foreign asset protection trusts. We like Cook Islands as the premier jurisdiction. There's a few different reasons. We won't go into that here. Since then, domestic jurisdictions started passing legislation to replicate what these countries were doing. So South Dakota, Nevada, Alaska, Delaware, they tapped into this and created statutes that allowed for what's called domestic asset protection trust. South Dakota and Nevada are known for having the best asset protection trust statutes within the U.S. And because of other reasons as well, South Dakota is recognized as the best asset trust or the best trust jurisdiction in the country. And that's where we prefer to do our asset protection trust domestically.
All right, so the pillars that we were talking about at the beginning of the webinar, they're interrelated with one another, and really they build on one another. You talked about succession planning earlier related to the revocable living trust, avoiding probate, and the power of attorney. What else do business owners and high net worth individuals and families need to be thinking about? Yeah,
so we could do an entire presentation on business succession planning, but just to kind of throw out a few quick ideas when it comes to succession planning. You need to be thinking about valuations, key employees, operating and shareholder agreements, buy-sell agreements, how to fund those buy-sell agreements with life insurance, the gifting of business interest, the selling of a business interest, and all the tax consequences that come along with that. And just as important as that is, you also need to be thinking about family dynamic and preserving family harmony. You spoke about that a little earlier. So, you might love your family, but leaving your kids unfettered access to money or the family business isn't necessarily helping them or anyone else out. So that's something to keep in mind and something to think through, something that we help clients with. And also, just because a business owner has a plan in their mind doesn't mean it's actually a plan. It has to be documented. It has to be written out, legally binding document. It has to be understood. It has to be communicated. A succession plan isn't something that happens overnight. So you need to bring all the key players to the table, your key advisors, whether it's your attorney, your CPA, your financial advisor, whoever your closest advisor is, to help facilitate and organize that process.
Yeah, that documentation and considering family dynamics and background are obviously very important. Is there anything else that a wealthy client, a business owner needs to consider when it comes to succession planning and building a legacy?
Yeah, so not a lot of attorneys talk about this, but the jurisdiction that you choose to do your trust planning matters, right? So you may not need to select a jurisdiction other than the one where you reside, where you live, but it can definitely impact your estate plan. So depending on your situation, you really might want to consider South Dakota for a handful of reasons. First, asset protection, and we talked about that in detail, so I won't really talk about it more. Next is privacy. So privacy is a big thing for wealthy clients, business owners. In South Dakota, they perpetually provide a seal on any details, any trust details that come out in court proceedings. So it's sealed from any public record. It will never become part of the public eye whatsoever. And then also South Dakota has what's called quiet trust laws. So unlike other states, if you don't want beneficiaries of a trust that you created to know about it, to have access to any information, you can completely eliminate them from being able to accomplish that. In other states, as soon as a beneficiary hits 18, you have to start letting them know about the details of that trust that they benefit from. So flexibility is another big thing. South Dakota allows for irrevocable trusts to be updated. So there's a lot of flexibility that South Dakota provides that other jurisdictions don't. That doesn't mean that we can't make updates to an irrevocable trust in another jurisdiction, but South Dakota just makes it really easy to be able to accomplish that. No state income tax. We'll talk about that in more detail here in a second, but that's one of the reasons to leverage South Dakota. And then next, dynasty trust. So you can have a trust that holds the family wealth in businesses forever, meaning that it will never be subject to any estate or inheritance tax because it's allowed to stay inside of that dynasty, that irrevocable trust in perpetuity. A lot of states don't allow for a trust to exist forever. So that's something that you have to worry about. Some states it's 21 years, some states it's 200, 300 years. It just varies. Some people will say, hey, I don't care. 300 years is a really long time. But if you're a wealthy client and you're going ahead and doing your trust planning now, why not go ahead and think through that? Maybe it's something you don't take into account, but it's because you don't want to for whatever reason. Thing is, know about it and plan accordingly.
Yeah, I mean, they're really in all, I mean, they're incredible. Like all those reasons. I love the privacy. I love the flexibility, the dynasty, and of course the no state income tax as well. So you're talking about multi-jurisdictional planning. A client could be in California or Texas, and they might be interested in these, superior laws of South Dakota. How is Stuart Green Law able to help clients that live in different jurisdictions than where you're located or licensed?
Yeah, so this is kind of interesting. I was having a conversation with some financial advisors this morning about this, and one of them was like, interesting. In 30 years of doing financial advising, I've never really heard anyone talk about this. So yeah, we work with clients that live everywhere, and so the thing with high net worth clients, with business owners, is they have very super complex and unique circumstances. So that means needing to leverage the best laws that are available to accomplish the client's goals. So let's say, the client is located in California or New York, but they're interested in tax, privacy, asset protection, the laws, the benefits of South Dakota. But let's say it goes beyond there. Let's say they have a child that lives in Texas, a child that lives in Florida. Maybe they own some real estate in Wyoming. They like to vacation there during the summer, get away. Maybe they like skiing, so they're going to Wyoming. Maybe they have another home in Colorado. There could be a lot of different things that are presenting these multi-jurisdictional issues. So you can't piecemeal together this type of planning and expect the client to find an attorney in Wyoming, one in California, one in Florida, one in New York. So what our strategy here is to basically be the personal family attorney and coordinate. So we're going to come up with the entire strategy, and we're going to look at all of the jurisdictions and figure out where it makes most sense to implement the planning. We're going to coordinate the entire plan. So that means working with local counsel in the jurisdictions where we're not licensed. We're going to make sure they're on board. We're going to make sure that the entire plan is legitimate in the eyes of all of these various jurisdictions. And then we're going to make sure that everything is correctly drafted and implemented according to those various jurisdictions that are involved. So it's a very concierge approach. Otherwise, it really would be impossible for a client to really address all the moving pieces that must be handled. So, estate planning isn't one size fits all anymore, and these multi-jurisdiction issues that pop up speak to that. It's very nuanced. It's a very comprehensive approach that must be carried out to truly serve the needs of owners or high net worth clients. And maybe there's even, international implications as well. Maybe it's a client who's in another country that has assets based in the US, or maybe it's a client who lives here. Maybe they aren't a US citizen, and they're a US citizen of somewhere else. So there's just a lot of different moving pieces. And so this multi-jurisdictional aspect of planning is more and more important. And we do a lot of it.
Yeah, and with estate planning, especially these complicated, estate planning, there's going to be tax implications, right? And I've yet to meet a person, I've yet to meet someone who wants to pay more than they need to in taxes, and often business owners and high net worth clients they're just paying more than really is necessary.
Yeah.
And a lot of people don't realize that you can leverage trust planning to minimize income taxes. Can you explain how that works?
Yeah, so along with asset protection, income tax planning, leveraging trust is greatly overlooked. So for clients that are in high income states like California, New York, New Jersey, Massachusetts, Oregon, I mean, really any state with income tax, there's a huge opportunity to implement South Dakota trust planning. So going back to that idea that they don't have a state income tax there, we're located in Texas, so this isn't really a Texas strategy for Texas residents. But for clients with large investment accounts or closely held business interests, we can transfer those assets into a South Dakota trust to avoid paying state income tax when you're, liquidating that business interest, or when you're selling off securities or whatever it may be. So we structure the trust in a way that gives you control over the assets, but removes them from your personal name and avoids state income tax.
Yeah, trusts are also used to reduce or avoid state income tax. So let's turn the conversation that direction. Tell us more about estate taxes.
Yeah, so there is a federal estate tax, and depending where you live, there also might be a state inheritance tax or estate tax. So I'll talk about the federal piece, right? So an estate tax means that you pay that your estate pays taxes on your cumulative wealth over a certain threshold. So inheritance tax means you pay taxes on the value of assets that you receive as inheritance. So there's a slight nuance there. These laws have thresholds, and they're constantly changing all the time. So the main takeaway is that you don't have to wait until you have a taxable estate to do estate tax planning.
So timing, is there a perfect time to do estate tax planning?
It just depends, and it's different for everyone. So for business owners, you might be worth, say, a few $1 million today. Even if you may not even be worth that, right? But as soon as you sell your business, you might be worth 20 million, 30 million, 40 million, or even more. We need to do planning before you ever have that liquidity event. If you wait until you have a taxable estate to do the planning, it's much, much more difficult. It's not impossible, but it just becomes more difficult. And I think we're able to likely save you a lot more in tax, maybe even completely eliminate estate tax if we're able to do the planning well in advance of a liquidity event.
Yeah, so just a minute ago, you mentioned that estate tax laws are always changing. Can you tell us a little more about that? And is this why you shouldn't wait till you have that taxable estate to do tax planning?
Yeah, exactly right. So today, your estate is taxed on anything, as of 2023, your estate is taxed on anything over $12.92 million per person. So a couple would be closer to 26 million, right? However, that changes in 2026 and will change to 5.5 million plus whatever inflation is. So it may be around 6 million or something like that. So here's something else to think about. Even though you yourself may not have an estate tax issue when you pass away, your kids very easily could. So let's say, you're able to pass each of your children 5 million or 10 million, and maybe that doesn't put you within a taxable estate. By the time your kids pass away, that money could grow significantly. Maybe they're doing really well on their own. And the tax laws are pretty conservative as far as who gets taxed and what gets taxed. So you doing planning today could be very, very helpful for your children in future generations down the road when it comes to estate tax issues. So point is, it should always be on your radar. Just because it's not an issue today doesn't mean that it won't be an issue tomorrow. So I like to have the conversation now, educate the client, put it on the radar, something for them to think about.
Yeah. All right, so let's talk about that last pillar, which is charitable planning. And most high net worth individuals and business owners, they have, missions that are close to their heart. There's organizations that they love to donate to. And there's different approaches to charitable planning, including charitable trust, donor advised funds, and outright gifts during their lifetime. So tell us a little bit more about some of these strategies.
Yeah, I won't go into great detail here. Just kind of give you some of my favorite things. I love donor advised funds. Most financial institutions have donor advised funds. A lot of people aren't familiar with them, but a DAF account, as it's called. It's just a charitable investment account that appreciates tax-free, and you can recommend grants from your account. They go to public charity at any time, whether you do it immediately during the year that you make the contribution to the account or years down the road. But you do receive a charitable deduction in the year that you donate money to your account. So it's a way to reduce your taxable estate. It's also a way to reduce your income tax by being able to take a deductible on your contribution to charity, a deduction rather. And if you're facing a liquidity event with your business, or you have low basis securities, then maybe moving assets to the DAF account, it makes a lot of sense. It could bring a lot of tax relief from income and estate tax perspective. And, you see charitable remainder trusts on the slide here. They work very similarly to DAFs as far as the benefit that they provide. There are obviously some nuances because it is a trust. I won't go into the complexities of that here, but know that, whether it's low basis securities or a liquidity event, you could put assets into the charitable remainder trust to reduce your income tax as well as your estate tax. So there's a lot of different approaches. It just depends on whatever the client wants to do. What I've realized from clients is that they want to see the benefit of the contributions that they're making. So a lot of people like to do build their charitable legacy during their lifetime. They like to begin it during their lifetime. So there's a lot of things that we can do to help facilitate that, make sure they're developing that legacy during life. And then if they want to continue, maybe a family legacy after they pass away, then we may look into things like charitable remainder trust or a few other things.
Yeah, that's fantastic. So that's all we have for today. We're confident that you're going to have more questions about how estate planning and, about estate planning and how it relates to your personal circumstances or maybe your clients. So feel free to reach out to us if you have any questions.
Yeah, so like Rob said, reach out to us. Here's our contact information again. We're going to send a recording of this webinar out to anyone who registered for it. Like I said earlier, if you signed up, we're offering the free consultation, so take advantage of that. A lot of value there, as well as Rob mentioned, with Cultivate Advisors and the business evaluation they can do to help grow your business. Free 2-hour consultation there, no commitment. Also, something that's really interesting with them is they have a proprietary tool that they use to help give business owners some idea of what their business may be valued at. It's just a good starting point. Wouldn't necessarily use it for maybe selling your business or anything like that. You would want something more official. But a lot of business owners, they think their business is either worth a lot less or a lot more than it's really worth. So it helps give you an idea of maybe what it's worth. And then if you want to get it to, maybe you think it's worth 10 million, you do this valuation, you realize it's only worth 3 or 4 or 5 million, but you want to get it to that 10 million spot because you're looking for a liquidity event, you'd like to get out, you'd like to receive 10 million. They can help you come up with that game plan of how to increase the value of your of your business, looking at sales and profitability, leadership, marketing, the entire spectrum of things. So take advantage of that. Reach out to Rob. He really quarterbacks that process. So we want to thank you again for joining today. Reach out with any questions, and we hope to hear from you soon.
Thank you.